Hi, welcome to the Property Show. I'm Jayashree Kurup. I'm Editor-in-Chief, MBTV, and I have with me Sudip Mullick. He's the partner real estate with Khaitan Co. Thanks, Sudip, for joining us.
Pleasure, man.
Sudip, we've had a large number of queries that our consumers are sending us, and all related to real estate and various legalities of it. So we thought, who better than you to answer these queries for us? There is Naresh Kumar, for instance, who recently shifted into a newly constructed flat. He got the flat after a delay of 5 years. He wants to know, can he claim compensation for the delay?
You see, if Mr. Kumar has shifted into a new flat, I am presuming that occupation certificate has been procured before he shifted to the flat, because that is the law. He could not have occupied without the occupation certificate. And if occupation certificate is there, then it may go out of the realm of RERA. And in this circumstances, he may claim a compensation, but whether the forum may not, the right forum may not be the RERA authorities, but maybe the consumer court or a civil court, whatever he chooses to.
So, Sudip, before we move on to the next question, maybe you can tell the consumer what are the forums that he has at his command for various real estate grievances.
Consumer in an ongoing project, as is defined under the RERA Act, as well as new projects, will have, if it is not delivered within the promised period, then he can go to the RERA authorities. But consumer court is not closed. He also has the option of going to the consumer courts. But the best option in those circumstances would be to approach the RERA authorities. He can also go to the consumer courts in case of second sale. He can go to the consumer courts in case of where there is a promise that has been made by the, and say in this particular case of Mr. Naresh Kumar, he has the option of going to the consumer forum because there was a breach of the agreement, there was a requirement, he has not suffered. But what terms and conditions, when he took possession, whether he has relinquished his right, what happened, or whether the developer may have delayed for 5 years, but the delay was due to force majeure conditions as was provided for in the agreement or allowed under law. I do not know the facts clearly.
Right.
Once you know the facts clearly, then it is easier to advise. But forums usually are the RERA authorities, consumer court, or the civil courts. Right. You see, there are in certain circumstances you can invoke the jurisdiction of criminal courts, provided there is actually a breach. But there is no point in arm twisting a developer in terms of filing something in the criminal court just for the sake of filing. So it should not be used as a sword. It should be used where there is a genuine fraud or criminality involved. Otherwise, the criminal court should not be used as a mechanism to get back a civil remedy.
So, Sudip, what are the advantages of going to each court, and when should a consumer go to each one?
The fact is, because RERA has been particularly set up for new projects and ongoing projects, and the mechanisms are also prescribed, there is a time-bound manner within which the authorities have to give their decisions. Maybe the proper forum would be the RERA forum, because it's a special court any which way, special authority any which way.
So it becomes faster than the consumer courts?
Should be.
Because it has only one subject to deal with.
Correct.
Thank you. Let's go on to another consumer, Naresh Singh, who lives in a high-rise society in Greater Noida, where there are a total of 12 towers. 8 have been completed and the construction work is going on in 2 towers. His tower is completed, but he faces a sewage problem there. And he's also saying that he has other issues like lift safety and cleanliness, which is not being properly maintained by the builder. Whom should he go to? RERA?
You see, for structural defect and workmanship within a period of 5 years, if it has occurred and this workmanship is not due to his fault, then in that circumstances, I would reasonably presume sewage problem would be a workmanship issue. He may knock the doors of RERA. But as far as others, the lift issue and there was something else. Maintenance issues, these are not really a RERA issue at all, because it is all between the buyer and the seller. So it will have to be taken to the consumer court, because this is a service that is being provided by the builder. But we'll also have to see to what stage the builder is, whether the builder is obliged to provide that services under the agreement, or the obligation of builder ends with the occupation certificate. Who is responsible, whether it is the association who is provided, whether he is part of the association, how has it been taken, whose responsibility it is. We'll have to identify responsibility and then appropriate forum he can approach. But if it is the association, then he'll have to possibly deal with the association first. Or whether the builder, how is the builder retaining control? Is it the builder who's retaining control, purposely taking money? What is happening? We need more clarity on the subject.
There are many instances in which the developers come forward and solve this problem. And even if you go to RERA, correct me if I'm wrong, Sudip, even in RERA authorities, the process of conciliation and coming to a discussion table and sorting out the problems seems to be the way forward.
It's not about law. It is reality that it is better to solve problems by negotiation rather than taking or confronting the developer or any of the service providers. It doesn't help anybody. Right. Now, if there is a truant service provider, then it is a different matter. But if there is a genuine problem and if a person needs time, instead of to solve the problem amicably is always better than going to any forum for the resolution of the dispute, because it will any which way cost money.
That's right.
And it will also create an acrimonious, unfriendly situation. So it is better to resolve these issues, be supportive of one another, rather than fighting over these issues and taking it to until unless you have to.
Absolutely. If the builder doesn't budge, or if the authority doesn't budge, or if you find that there is no other resolution, then of course that's why RERA was created, that's why we've got a consumer court. But as far as possible, try and resolve it at your level. And today I think developers are more than happy to come forward and amicably resolve issues, right? We'll take Sudip Gupta's query, where he says his flat is still not registered with the authority, but he has got possession of the flat. I noticed that the builder has not made any provision for fire safety inside the flat. Can RERA help in this matter?
Again, this is a case where occupation has been taken. Registered, I would presume he means registered with the registration office, and it is not with RERA. So RERA would not really have a role to play. He must make an application to the appropriate sanctioning authority to take steps or give notice to the developer to rectify that. And in the event the sanctioning authority deems fit, they will instruct the developer to carry out or will act according to the provisions of the act that is governing. So say a fire safety or whatever it is, and they will take the developer to task. You don't have to do, you merely have to complain.
These are the mandatory clearances, right? Fire safety, environmental clearances, mandatory clearances. So these are things that the authority, like if you're in Greater Noida, it's the Greater Noida authority. If you're in in other cities, it's the municipal authorities. You have to go back to them, and that's where whoever is the authority that gives all the clearances to the developer, you have to go back to them. There is Ashok who says, can the RWA collect maintenance charges irrespective of the fact that the building doesn't have an OC? Without an OC, can they stay in it?
No, without an OC, one cannot occupy. That is the purpose of an occupation certificate. So if you are staying in a building which does not have an OC, then you are actually doing an illegal act. And in any event, it is the obligation of the developer to carry out maintenance till handing over. Handing over can happen only after OC. So if there is no OC, nobody can collect.
Then there's no RWA, and even the developer cannot collect till he gets the OC, right? There's Rajesh of Mumbai who stays in a single building society containing 12 flats registered under the Apartments Act. Of the 12 flats, only 4 are interested in conveyance. Others are of the developer and they are not interested. How do we get the conveyance done?
You see, there is a provision of deemed conveyance under MOFA, which also should be governing MAO. And the fact is that in invoking section 11, the association has to take a big role. Now there are 4 individuals and they are minority any event, so it is better that they go to the civil court and file for specific performance rather than taking any other route.
Because there is no RWA, right? Functioning RWA. Srinivasan is an NRI and wants to know how an NRI can sell his property. What papers does he need to sell? Also, there are specific provisions for NRIs, right? Right.
As far as NRIs are concerned, there are about 2 properties, residential properties, and there are various types of accounts that, but principally NRIs, their TDS will have to be deducted on capital gains after taking into consideration the capital gains are not at the flat rate. Plus, NRIs can only repatriate up to 1 million USD in a particular year if it is from a particular account. There are various accounts. In some cases, there are no limits, but generally there would be limits. And property papers, you see, he will have to execute the regular papers that is required to be done. There are certain nuances in terms of power of attorney. If it is executed in India, it has to be registered. If it is abroad, then there is a certain process that has to be carried out. So these are the nuances, but he'll have to carry out the necessary, he will have to execute the necessary documents that are regularly required for other conveyances.
There's nothing special that an NRI has to do. So there you are, Srinivasan. An NRI does not have a special status as far as selling property is concerned. Repatriation and your TDS are the two things you have to be aware of. John Costa is the secretary of a society in Goa. He has two questions. What date does the maintenance start? Occupancy or possession? And if some people don't pay the maintenance, what action can be taken?
You see, it will be, if you have taken, it has to be after occupation certificate, but whether you have taken possession or not, it will be governed by the terms of your agreement. But definitely with the occupation, if you have taken possession earlier, which you ought not to have taken, then it's a different story. But otherwise, it will only be from the occupation certificate.
And the second question is, if some people don't pay the maintenance, what is the action that can be taken?
If some people do not pay maintenance, you cannot really take coercive action against those people. You will have to take recourse to the provisions of law. You will have to apply to the authorities and say that they are not paying the maintenance. Appropriate proceedings will be carried out. Then there will be a charge on their asset. If they are not going to pay, then the asset will be sold by a process of auction or whatever to recover the maintenance. I think one needs to, instead of, I will disconnect your electricity, I will disconnect your, these are things which you should not be doing. You should be taking steps in accordance with law of filing appropriate proceedings before the appropriate authority.
Sudip, just before we close, are consumers, you deal with a lot of developers, consumers, are consumers actually conversant with the provisions of the law, or do they go into confrontation because they don't understand the law?
I think consumers are aware of the law, but what happens is there is a herd mentality. There is a mentality, you see, in today, what I see today, rightly or wrongly, I do not know. I see that the new act has come into force. I am entitled to this compensation and that compensation. You see, I think the focus should be, I should get a completed project. Instead of trying to say that I will send him to jail, I will try to get this benefit. But after all, we are human beings. We will try to extract or get as much as we can. No harm in it. But the fact of the matter is, the whole objective is to make a clean environment to complete. As I have repeatedly said, there is no point in sending a developer to jail. The whole purpose would be how we can effectively complete the ongoing projects. The new act is brilliant. It will help clean up, and we will have proper projects that a consumer, it will help in the economy also, because consumer knows that he will get the product that has been promised to him at a promised time. Now, ongoing projects has many problems. Now, some projects have genuine problems where there have been environmental issues, where there have been regulatory issues. So, say for some point of time, in Bombay there was this airport issues, so height restrictions issues. Now, if there has been a problem, we'll have to address that problem. We'll have to give time. But if you are saying that no, it is very easy to say my project has been delayed for say 7 years or 10 years. I want my money back with interest. This is good, and this will happen if the prices of the property have gone down. So what you are really looking at is a return of your investment, which is practically double. But what people forget is when you invested in the project, you also took as much risk in the project as a developer, because people have done everything. They really went into the project not knowing the completion date, not knowing when it will be handed over, not knowing, but it was a risk they also took, because they thought that the market will rise and I will profit from it.
Right.
So that is where the situation is. Now everybody then launched projects. Some projects actually became unviable. Some projects, there are a lot of factors. Right. Now I am not saying there are that some developers have not been truant. Maybe they have been truant. They may have channelized. But some developers given some support, whether from the government agencies, whether from the government itself, whether by the unit holders themselves, may be able to complete and deliver a project. It's better to have something in hand than to chase a dream by fighting a battle in the court. It makes no sense.
A completed asset is always more valuable than a stressed asset. Therefore, like we said earlier, focus on #complete stuck projects. All projects need to come to completion. After that, you can decide whether you want to fight for the compensations. But right now, the focus is on completing the stuck projects. Thank you for watching the Property Show. Please subscribe to Magic Bricks on YouTube and click the bell icon to get new videos.